If I missed anybody, please let me know. Does anybody wish to speak on anything that's not currently on the agenda? Okay, I'm going to move on to consent items 1 through 18. I'm now going to open public comment on items 1 through 18. I will first go to, let's see here. I guess these are all above that number. Is that for, Jordan, is that in a 1 through 18? Okay. So we have no speaker request forms on items 1 through 18 consent items. I'm going to close public comment on those items and now move on to the council to remove items from the agenda. We'll go to Richie Nordstrom. Eight, 10, and 15. Okay, I have items 8, 10, and 15, and I recognize Wade Nyberg. Moving item number 5. Any further items removed? Yes. Well, he took 8, 10, and 15. Okay, I'd entertain a motion to approve the balance.
So moved.
Motion by Nordstrom, second by anyone? Mr. Wright, to approve items 1 through 18 exclusive of 5, 8, 10, and 15. All in favor say aye.
Aye.
Opposed? Motion carries. We'll go to item number 5. Authorize the mayor and finance officer to sign memorandum of understanding between the City of Rapid City and the Rapid City Area School District for entry onto property for wildlife mitigation and fuel elimination. And Chair recognizes Wade Nyberg, the attorney. Turn your mic on, please, sir.
Nothing.
Not a voice. What a shame. Okay. Well, so would you like us to continue this item?
I would ask that you take it to council without recommendation.
Okay. Motion by Wright, second by Nordstrom to continue this item to council without recommendation. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Item number 8 is a resolution 2015-022A, fixing a time and place for hearing of assessment roll for cleanup of miscellaneous properties. Chair recognizes Richie Nordstrom.
Thank you, Mr. Chair. On the link that's attached on the code enforcement property status report, I'll look to our community resources person, Mr. Barbier. If you've got an update for us.
Jeff.
There was not a link to that status report. Can you help me out?
I'm sorry, I don't have an update for you on that. I didn't look through that particular item. There isn't an attachment?
Yeah, and I see Barb Garcia is coming into the room, and we were just talking on the phone just a few minutes ago about the link for the status report. If I may ask Barb a question.
Barb, if you please approach the mic and identify yourself, please.
Barb, have you had a chance to get the link attached to the item number 8?
No, I just got them looked up.
Got them looked up, okay.
I can tell you, only 2 of them were first offenses. Everything else were multiples. And I'll get it linked for Monday night.
Thank you. Mr. Chair, if it's, that's all I've got.
Okay, and I currently have no motion on the floor.
Can I make that motion?
Alderman Wright can.
Make a motion to send to council without recommendation.
Second.
Motion to send to council without recommendation by Wright, second by Nordstrom. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Item number 10 is Resolution 2015-032, authorizing and directing the issuance of sale and water revenue refunding bonds, Series 2015, defining the terms and manner of payment of the bonds and security thereof. Chair recognizes Richie Nordstrom.
Thank you, Mr. Chair. First, let me do the motion to approve.
We have a motion to approve by Nordstrom, second by Weifenbach. You have the floor.
Mr. Chairman, I think I know the finance officer has some good news for us on this item, and if I can look to Pauline Sumption for a comment about this item, is saving us a lot of money on the bond.
Chair recognizes Pauline Sumption, the finance officer.
Thank you, Mr. Chair. Depending on where the interest rates are when we actually close on these bonds, we are looking at saving anywhere from $2.5 million to $3.5 million over the course of the bond with no additional time needed. So they would still term at 2039, I believe, is the year.
Thank you, and that's all I have.
Chair recognizes Alderman Ron Weifenbach.
Thank you, Mr. Chair. I have a question that talks about the water department. There was a transfer of land ownership from the city to the airport involving a piece of land on the Wally Byam that they transferred for. That came out of water fund revenues, and I just wondered if that's ever been replaced.
I'm not sure who that question directed to. Pauline Sumption?
Thank you, Mr. Chair. My understanding is that the water, or that land technically is not the airport's yet. It's still showing just as part of the city. The water department has not received any funds for that. I have not been directed to do such at this time.
Okay.
Thank you.
Motion is do I have a motion to approve? Yes. The motion is to approve. Any further discussion? All in favor say aye. Aye. Motion, any opposed? Motion carries. Item number 15, authorize mayor and finance officer to sign federal assistance SF 242 and CDBG certifications. Chair recognizes Richie Nordstrom.
Thank you, Mr. Chair. And first of all, let me make the motion to authorize the mayor and the finance to sign this assistance and certifications.
Motion is to approve. Any second? Second by Weifenbach. You may have the floor, sir.
Thank you. Is Barb Garcia still in the room?
She's in the back.
Oh, there she is. I just wanted to mention a couple of things on the worksheet that it has attached to the link here. Primarily wanted to, if I may, Barb, a question for you on the housing part of it has to do with that third column we were looking at in the cream colored section, and right now at this stage we don't have any funding going for housing.
Chair recognizes Barb Garcia.
That's correct. The investment committee, actually there's one activity on there that is housing. That's Lutheran Social Services. The only other application that was for housing was Dakota Land Trust. But they weren't funded because they currently have not completed using all of the funds they have now from previous, ran over here, from previous years. So we had allocated $100,000 to Cornerstone out of 2015, but because we had 2014 money left that we needed to spend, they withdrew their 2015 application, and we funded them with 2014, which council approved back in, I think it was December.
That sounds right. I kind of remember that time frame. So, Barb, what we're looking for is some more nonprofits or some other individuals, maybe a private entity that could help us out in the housing area? That these people could be applying for CDBG?
That's correct. The investment committee had put out a request for proposals that was specific to certain categories of housing that are what are our higher priorities, and nobody chose to apply for those funds at that time. They didn't have a lot of notice, and it takes a while to put together those kind of deals. So the $100,000 we recaptured from Cornerstone was put into the contingency fund that's in there. Those contingency funds can be used for housing, and I will be coming back to council to request your authorization to reallocate that 200 and some thousand plus another 200,000 that's left over from previous years. So there'll be a reallocation of 400,000 probably after the next council meeting that will be specific to housing, public facilities, or economic development.
Thank you. So in essence, what we're doing today is getting the word out so that people should be aware of something is going to be coming for housing. Thank you. Thank you. I'll yield the floor.
Okay, any further discussion? Motion is to approve. Any further discussion? All in favor say aye. Aye. Opposed? Motion carries. That ends consent items 1 through 18. We now on to non-consent items numbers 19 through 25. I currently have quite a few speaker request forms on item number 19 and one for 26. Does anybody wish to speak on any other items that haven't got their things in yet? Brad?
I'd like to just talk on number 19 before they get started.
Okay. Brad Solana, you want to go and identify yourself?
Yeah, I am
Oh,
reading.
18's already on there. It's consent. Okay.
Thank you, Chairman Lewis. I'm Brad from Development Services. I just wanted to fill you in on what's going on today with number 19. That's the residential code adoption for the 2012 International Residential Code. I just wanted to let you know that the building board first made a decision in March of 2014 to look at the 2012 codes, draft some ordinances, run them through. They had discussion on early ordinances and draft ordinances in April and May of last year. In June, we had the engineer Mike Albertson come in to the meeting. He gave a good talk on the structural tables and things, and made some recommendations there. In July, the board made a motion to take the ordinances that were drafted to public hearings. So we had a number of public meetings on all of the codes that got adopted. In September, the Black Hills Home Builders and those groups met and talked about the ordinances that were drafted. In October, there was a motion to pass these ordinances on to legal and finance. Now, the building code, the property maintenance code, the mechanical code, all those other satellite codes were approved here, and they went into effect at about Christmas. The residential code wasn't done yet, and so in the public meetings we had in October, around there, and at the building board meetings in October and November, there was a bunch of public comment that was received. There were some changes made to the residential ordinance in November. There were some changes made in December. In January of 2015, we had two local civil engineers appear, Robert Timmy and Mr. Fisher. They gave good information on the soils, which you're going to have a discussion here about here shortly. And then in February, of course, they had some more discussion and a couple more changes. And then just recently now in March, the board voted to pass this final draft ordinance. And so I just wanted to fill you in on that. And like I said, there's a bunch of speaker requests forms, so on various parts of it. So I'm finished. Thank you.
Thank you. Okay, first speaker request form is for Dane Brunsba. Excuse me. Okay. Chair recognizes Jeff Loggy. If you could just introduce yourself. You have 3 minutes, sir. I'll give you the time to walk up there, don't worry.
Yeah, it takes me a while. Jeff Loggy with Loggy Construction, and I'm also the chairman of Government Affairs for Black Hills Home Builders Association. I'm going to speak on two issues right now. The first issue is the soils testing plan. And correct me if I'm wrong, Brad, as we go, or you can come up and correct me when I'm done. But the way the existing building code reads is it says the city shall require soils testing. So the terminology that came in here in the soils testing area kind of lightens that, and essentially what it means is that a builder shall consult with a soils professional, and between the builder and the soils professional, they will determine what the best procedure is going to be. I'm in favor of that portion. The part that's always tough to accept here is there is costs associated with this. There's costs associated with this in regards to hiring the professional, and there's also potential cost in this if you are building on soils that require over excavation and engineered fill. In those areas that are the primary focus of this, and that's what came up during the building review or in the committee meetings, or on the expansive soils with heaving floors and things like that. There'll be greater costs associated with that, but you have areas right now like that where you have builders doing over excavation and you have builders not doing over excavation. The ones that are doing it are spending more money, put more money into their houses. The guy next door isn't doing that. So hard to get equal valuations for those type of properties. So when you look at it on that side, it's kind of that double edge. Yes, it's going to add cost, but it's going to add equality in some of those areas. And housing affordability is such a huge issue. It's hard sometimes to swallow and accept more costs going into the house. But in a lot of areas, this will be very minimal, more of just a consultation, maybe a 1-hour trip out for a professional to see the excavation while you're doing it, or perhaps a profile hole. The other issue that's kind of on here but has been removed from here is the unfinished areas in basements, requiring a minimum of half-inch sheetrock on the ceilings, and then in mechanical rooms if they are unfinished and over 80 square feet. In an unfinished basement, that's always potential new house or new area for a homeowner to come in, and it's cost that's saved to get in a house that's maybe bigger than what you can afford right now, but maybe later on can afford to finish the basement. And in lieu of the half-inch sheetrock on the ceilings, there is a stipulation in there where you could do a residential fire sprinkler in lieu of that. Either of these issues do have cost. The building materials that are used in these have been around for 30, 40, 50 years, and the structure. So it's kind of interesting this is coming up now. And again, it's affordability, and I'm in support right now to have that portion removed from this code. And then in future code hearings, through a lot of stress from NAHB, all future codes will have a price tag attached to them, so all of us can evaluate the costs later and in the future, and of course be arguing that point.
Thank you, Mr. Loggy. Did you want to speak, sir? Okay. Jeremy Muth. Okay. I'm going through these fast now. Dave Ashbridge. If you identify yourself, sir, you have 3 minutes.
I am Dave Asbridge. I am the chairman of the Rapid City Building Board of Appeals, and I just want to make a couple of comments. First is that the two issues I think that are going to be debated today on item 19 is the soils and the fire protection of the underside of floor systems in unfinished lower levels. I will tell you that our board spent a great deal of time. It was not a knee-jerk reaction. We had attorney. We gave him the opportunity to vent on a number of occasions on the soils testing. We brought in engineers, and we, I think, came up with a great solution to the soils testing issue. It satisfies, I think, the builders and the developers of this community, and it should satisfy the buying consumer. On the issue of the underside of floor systems being protected at a minimum of a half-inch sheetrock, that was also vetted quite extensively in our meetings over the months. And quite frankly, I think what it boiled down to, as far as the vote of our board to strike that chapter out of our code, was appropriate, just because there is no compelling reason that we could find that we should keep that clause or that chapter in our code. After investigating around the country as to how many jurisdictions have adopted that, and especially in our state, there had been no adoption of that chapter to date of that. And again, I think Mr. Loggy is absolutely right on. There is affordability issues with this. And I'm not speaking on behalf of the board at this point. I'm speaking on behalf of the consumer. We're the only defense as builders between regulatory burden and the consumer. And so I just would appreciate you, in your deliberation, consider those things. Thank you.
Thank you, sir. Chair will recognize Mike Whalen. Yep. Identify yourself for the record, sir, and you have 3 minutes. Within 30 seconds, warnings when the yellow light comes on. Thank you.
Thank you. My name is Mike Whalen. I'm an attorney who's practiced here in Rapid City for 20 years. For 10 years before that, I was a state's attorney in Charles Mix County, represented numerous municipalities in that area. I'm here, much like Mr. Asbridge and Mr. Loggy. In particular, I want to visit just momentarily with regards to what appears at page 13 on your proposed residential code, and that is section R401.4, dealing with soil tests. I believe I am the attorney that Mr. Eskridge mentioned vented. I hope it wasn't that, but nonetheless, I think that you'll find that 3-page materials have been provided to you, including the Legal Minute article that appeared in the Black Hills Home Builders Association magazine last month, and it is entitled A Dirty Secret. It is an excellent summary with regards to the expansive soil issue that persists in much of Rapid City, and it also addressed some of the costs and other items that need to be considered. I would submit to you that this is long overdue. It has been since February 1972 that the USGS geological map has shown areas of expansive soil within Rapid City and throughout Rapid City. Please pull that up. And you'll see, hopefully pulled up here in a moment, that map. That map costs $20. It will inform anyone, developers, contractors, city officials, anyone who might be interested, including consumers, where the expansive soils exist. On this map, there is a legend in the upper right-hand corner, and below that, a particular cautionary note that sets forth those soils that are critical with regards to their expansive character. Now, I think it has been sort of the can kicked down the road on numerous occasions and not been addressed. And one of the reasons is because the cost is indicated by Mr. Loggy. However, if you compare that expense, $2,000 to $3,000 for the testing, and in addition to that, there would be costs for the over-excavation and replacement of that expansive soil. If you compare that on one hand against the amount of money that would be involved in remediation, and remember that there's 20 to 30 houses in litigation, so-called bad house cases, at any given time. And yes, I do represent some homeowners in that regard, but you're looking at remediation costs that will run, depending on the house and the location and the extent of the remediation, anywhere from $60,000, $80,000, $100,000. Currently, one house I have in litigation, the remediation bid was $167,000. I see my yellow lights going off, so I'm running. And I urge you to pass this as this amendment, and thank you for your time.
Thank you, sir. Up next, we have Tim Billings on item number 19 as well, sir. Do you need to get your props there?
Might take me a minute, yeah. I'll get those in a minute.
Okay.
Thank you. Might take me just a second to get this going. Thank you, and I'd like to ask up front for maybe a little attitude at the end for a very short presentation to further clarify some items on item number 19. My name is Tim Billings. I'm Assistant Chief with the Rapid City Fire Department. I'm the city's fire marshal, so I'm Assistant Chief of the Fire Prevention Division. I'm here today in a kind of unique position. I'm here to speak on item number 19, and in favor of the document overall, but with exception to item number 19 on proposed ordinance 6009. The specific section is International Residential Code, section 501.3, which I have up on the screen, and it's the section with the large dark line next to it. My position as the fire marshal for the city of Rapid City is charged with the responsibility to look out for and provide for a safe environment for our citizens, our visitors, and our firefighters that operate within the city and the surrounding area. Not unlike many other governmental agencies that are simply looking out for hazards and provide public safety. In the effort to execute my responsibilities within the city, one of those is looking at new codes and participating in the code adoption process and identifying areas that may have a negative impact or positive impact on our community and citizens. This particular piece, with the removal of that from the proposed code, we feel has a very strong negative impact from both a public safety aspect and a firefighter safety component. So like I mentioned earlier, I'm in kind of a strange position today because I support the ordinance overall and the hard work that the committee did. I really respect the work that they have put into it. I know they spent a long time at it. However, I do oppose this particular section being eliminated. It's really unfortunate that we did go all the way through the process to get to this point to have to speak to this particular piece. The board, as Brad Solon had mentioned, met on a lot of occasions, discussed the code very intently, and on this particular item specifically had been reviewed and approved, and then later removed and denied with and without fire department input. So the primary opposition that come to play on this particular piece, as I've learned to be, as Mr. Loggy had spoke to today, is cost. Cost was one component, and then the second component was other communities in the state or the country have not adopted it. I'd like to think that we actually think things through more thoroughly and take a harder look and make better decisions than maybe some of our other counterparts across the state and country. And that's no disrespect to them. I just think it's important and it's part of our responsibility. So cost is always a concern to us as well. When you get to this particular piece itself, you'll see that there really isn't a good reason to eliminate it. I understand the cost and the half-inch gypsum board, but there are other exceptions, other ways to protect it. You have 4 exceptions here. There's actually 7 other acceptable alternatives that I've identified over the last few weeks that would be added to this as well, that would be useful to protect that item, that may be less or more cost efficient and effective. So at this point, I think that part of the responsibility of not just the Rapid City Fire Department, but the board as a whole, is eliminating such a critical piece from the code is counterproductive to public safety. People that are buying new homes are expecting that their homes are fire safe and that it's meeting the minimum standard. And with the removal of this, they are not. I see my light has expired. I would ask for some latitude for a very short PowerPoint presentation, either now or later.
Maybe during the full council might be more effective anyway. I assume you'll be at council?
I will probably be at council. It depends on what this group does.
Yeah.
I
Let's just wait
for
and
any
see.
questions.
Thanks. Okay, item number 26, Mr. Jordan Mason. If you could identify yourself, sir, I'm sure you know the drill, but, you know, you're getting older now, you might sleep deprivated from having a child.
Yeah, well, I do have a child and sleep deprivation has kicked in. Name's Jordan Mason at 4021 Lakeview Drive, number 3. I did want to just speak on item number 26. I think that it's important for this council and this committee to take this to council, especially in light of the fact that Ordinance 6018 through the consolidation of the Vision Fund and the CIP was done for the sole purpose of the funding mechanism to expand the Civic Center. Now that we have gone through the vote and the referendum, I think that it's important to bring it back and to honor the citizens and their decision that was made. And more importantly, I would make the recommendation that this committee and for the council with the upcoming election, I think that the citizenry has a right to know whether or not you, each and every individual council member, are willing to refuse the interest and the spoken interest of the citizens. And I would encourage you to have a roll call vote on this issue at this committee and at the council. Thank you.
Thank you, Mr. Mason. Excuse me, I have no further secret request forms on any items number 19 through 28. 19 through 28, anybody wish to speak on any of those items is not currently spoken. Okay, I'm going to close public comment on those items and go immediately to number 19, which is introduction and first reading of ordinance 6009 to adopt the 2012 International Residential Code by amending chapter 15.13 of the Rapid City Municipal Code. Chair recognizes Jerry Wright. Did you want to speak?
I will.
Okay.
I'll make a motion to send this to council without recommendation.
Motion's to make it send to council without recommendation.
Floor.
Second, to Mr. Nordstrom, and you can have the floor.
Thank you. To all parties that were here and some that have left, I think the council is not going to make a decision on this Monday night. I would think they're not. I think there's a lot of deliberation we need to do. Only 2 of us on board that are engineers. The rest of them are civilians in different backgrounds. And we're all going to be concerned about the costs implicated with the different things, especially with the soils and the sheetrocking and fire protection. And I think we're going to need some time to deliberate so we make the right decision as a council.
Thank you, sir. The chair recognizes Alderman Ron Weifenbach.
Thank you, Mr. Chair. And I get the fortunate ability to sit up here and talk as long as I want, and I know that Mr. Loggy got cut off
no.
short there, so I would have a question for Mr. Loggy, if he's so willing to.
Mr. Loggy, would you please re-identify yourself, sir? We all know who you are, but the public may not.
I'm Jeff Loggy, with Loggy Construction, and also chairman of Black Hills Home Builders Government Affairs.
Thank you. The question I have is, it seems like there's a consent in the spirit of this particular soils testing that you're talking about, but I'm not sure I understand your position.
Our position is, in lieu of complete and total testing on every lot every builder has to build on, we've essentially, with a lot of conversation, essentially, we've come up with this plan, and what it reads in there, and I didn't bring it up with me, essentially is that a contractor will consult with a soils professional. Essentially, you got to have this done before you get your inspections on your foundations, when you start pouring your foundations. And essentially what that will consist of, and correct me if I'm wrong, anybody sitting out here, what that'll consist of is essentially a letter that you've consulted with a soils professional, and that you will do essentially what you're required to do. It really is designed to be between the builder and the soils professional. The city's just going to make sure they have the document in hand that this is being done. Some won't have to have anything done. Some may have to do some over excavation. Some may just have to do 3 feet. Some may have to do 4 feet. There's many areas of town where there's been a lot of soils data collected, and the reason that this compromise essentially came up, and to try to make sense of what this is just make sure there's a little review being done by the contractors trying to do the right thing when it comes to soils. Soils around Rapid City, we got everything here. And I've run into things all over town. Originally, when this was proposed, there was going to be designated by a street, that everything east of a certain street or whatever. But the Building Board of Appeals, or is that right, Dave? The Building Board felt that probably wasn't the right way to do it. It would really segregate certain areas of town. So in other words, instead of doing a full-fledged soils test, we're getting a consultation with a soils, and I do it a lot. Essentially, they come up while I'm doing my excavation, and take a look and say, yeah, you're fine, you're all in red clay, don't see any issues. A lot of times they'll say, do a profile hole before you get digging, and let us come out and take a look. Sometimes they'll take a soil sample back, do a quick test on the expanse, do different tests, proctor tests and things like that with that soil, just to determine what you're sitting on. But what it is, it's between the soils professional and the contractor.
The soil professional, who would that be?
That would be your geotechs. Okay. That are in town, and I don't exactly know how many. I know there's at least 4. I deal with a certain one, so and I think most people in here deal with the ones they're most comfortable with.
Right. So in essence, I understand you mentioned leveling the playing field, because I'll guarantee I look around here and I see some of the contractors I probably would have looked around 5 or 10 years ago, and some of these same guys will be here. Some of them that aren't here today probably wouldn't have been here 10 years ago. Over in Gillette, I'm used to what they do over there, and they pop holes in every lot, and then they get an engineer's certification that says this is how you're going to do this lot. Either you're going to put caissons in, or you're going to over excavate, or whatever. Does a soil professional person do that same thing, or?
They're going to be dictated by whatever they see on the job site. If they're familiar with the development, and they've already done testing in the development, whether it be during the development stage and they've done testing during that, or perhaps some of the builders already brought them out and did some testing. What this gives is that soil professional a little bit of latitude. It's up to them to decide if they're going to want full-fledged soils tests, with their comfort. But if they've already done, 15 houses in a 100-home neighborhood, they're going to have a good idea. So it's going to save cost from the engineering standpoint. that they can just, you know, essentially write a letter of recommendation to the builder and say, here's what we'd like to see you do. And within that recommendation, they're going to put their specifics, whether they need to come out and do testing of the engineered fill if it's in there, or just, you know, you're good, you know, we're done.
Do they have any accountability in the end?
Well, if you're dealing with, yeah, absolutely. I mean, there's accountability on both, you know, is what it is. They're going to give you the best decision, and if you're operating off of a note or a letter that's given to you, if you're doing it that way, yeah, I mean, there's always accountability there.
What does it cost for over excavation? Is it successful? I guess does it work? Does over excavation?
Well, I'll
work?
defer. I have, you know, Dane Boomsman here. He's an excavator, so I could let him come up and testify to that.
Dane, if you want to answer that question, that'd be awesome. Because I understand, you know, the building codes. I watch these things, and I have friends that are builders and whatever, and some of the stuff makes no sense at all, and we leave no flexibility in the end, and all we do is cause red tape. But Dane, does the over excavation actually work?
So Dane Boomsma with Black Hills Home Builder, First Vice P, Boom Construction, and then Professional Excavating. So I do quite a few basement excavations in Rapid City, all over. Jeff Loggy, Jeremy moved, so I'm all over town, and I see the vast variety of soils that we have. There's certain subdivisions that we don't do soil testing right now because we know that it's bad soil, and we do 4-foot overdig. When we were building houses in those same subdivisions in 2003 and 5, and we weren't doing it, there's several that have had floors torn out because of that. In climate changes, when the water level in the ground changes, then the shales expand. So in some subdivisions, like I said, we do 4 feet. We do as little as 2 feet per the engineer's recommendation. I have never went back into a house that we've done an overdig and put engineered fill in and had problems with expansive soils. So to answer your question, yes, the engineered fill works.
Okay, what does that cost to do that?
2 feet, you know, $5,000 to $10,000. I would say 2 feet on a 1,000 square foot house might be a little under 5. If you did 4 feet on a 1,000 square foot house, you might be pushing 10. You know, that's material, because you got to buy the material. Obviously, it's a processed material that we get, you know, just north of town or out off Red Hill Road. There's another pit that we can get to.
So, do you use a soil professional, or do you have a geotech come out and punch holes, or?
Well, what we do to save cost, and that's one of the reasons that we made the recommendation on the ordinance that we did, that we don't have to have the letter to obtain a permit. We have to have the letter prior to a footing inspection. And the reason for that is so me as an excavator, I don't have to make 2 trips. I can go and pop a hole in the middle of the building site, start my utilities, my water and sewer. That gives the geotech time to come out and look at it, issue a letter prior to the concrete guy needing an inspection. That was the reason that we put that in the ordinance, just so that it's not a delay and it's not as much cost. So me as an excavator, I'm not charging to punch this hole. The geotech's going to come out, and like Jeff said, you know, they're going to charge by the hour, and that's $300 to $500 usually for them to come out, go back. If they're unfamiliar with it, they may run some tests, some plasticity tests, stuff like that. If they don't have to do that, like you said, if they're familiar with the subdivision, they may just come out and look at it and be able to simply issue a letter based on their past experience. So the engineering cost, I don't really see as a big variable. If I go into an area that I'm not comfortable with and the contractor I have doesn't want a soil test, I do it anyways and give it to them because the cost is so minimal, and then I'm not liable when they make the decision not to do it. I'm a big supporter of the overdigging. We've been doing it for probably 6-7 years now with no issues.
Okay. You've clarified a lot for me, guys, so I appreciate that. And then I'm going to go on to that second part of the 80 square feet in the basement, and I'd like to ask Tim Billings a question.
Mr. Billings?
Mr. Chair, thank you.
Thank you.
Thank you. I understand and I respect your position on providing safety for the community, and one of the questions I would have is, do we have statistics or whatever, some information that is made available to us that we can better get a grasp of why this would make such a big difference in what they're doing now?
We have some data we can provide for you. Local data. The actual day that this provision was voted to move it forward to you folks, We actually had a fire out in Black Gap area where we had a floor failure for the very reason that this thing is to prevent. And the following day after that, there were 4 firefighters that went through a floor in Georgia on a new construction for the same reasons. So we've had at least 4 incidents that I can think of in my tenure here with Rapid City, in or around the city, where our own people have gone through or partially through a floor, an unprotected floor assembly. And up until this edition of the code, it wasn't required. So this is a reactive piece to a long-standing issue, as Mr. Loggy had alluded to earlier. So
You're saying that half-inch or piece of sheetrock makes that much difference in that fire protection if the fire starts in the basement or fire starts in the top level?
if it's within the basement area. The issue that we have at hand is modern construction, which is lightweight construction. I refer to it as high-performance construction because we're spanning greater lengths with lighter materials, engineered materials, just as we have up here in front, a joist or truss assembly or an I-joist, TJI type of assembly. Those are very, very good products, and there's absolutely nothing wrong with how they're used. They just don't react well to fire. So our structural collapse times in structures of old conventional or legacy type construction, we've had 18 minutes or better to work with before we have collapse. Now we have collapse in an average of about 6 minutes or less. That's about the time we're getting on scene in most cases. Best case scenario, if we have early notification of the fire. The other thing that compounds this is today's furnishings. The fire environment is vastly different today than it was even 10 years ago. And so we have full room involvements, which used to occur in about 4 to 5 minutes roughly, are now occurring typically in under 2 minutes, about 1 minute and 50 to 3 minutes maximum throughout most UL tests. So it's really a combination of things that we're protecting from, but keeping that structure intact is huge. From a firefighter's safety standpoint, when we enter a structure, we use a thermal imaging camera typically to help us identify where the location of the fire is and also identify structural issues. The flooring materials, carpeting, so forth, tend to hide the loss of that structure. And so we may only have surface temps of 80 to 100 degrees, but the floor system is already gone or disappearing as we go. So it's a collapse. That's how our firefighters end up going through the floors early.
So we have real life examples of.
We have real life examples.
Like shows a new construction house versus an old one that has the same no basement finished.
Yes, sir.
Okay, if you can share that with us, I'd appreciate it. And that's all the questions I had. Because we're going to move this to council without recommendation, obviously. But thanks.
If I may ask one thing, if you had about 3 minutes, I could run through a series of
I think we're going to watch that at Monday's council.
Okay,
I think it'd
that's
be
fine.
better to present it all at one time. I just
Cool.
had some questions I wanted to think about over the weekend, so I appreciate it.
Thank you.
Thank you.
Chair will recognize Richie Nordstrom.
Thank you, Mr. Chair. I've got some considerations to take into, we have to look at a couple of different issues on this whole thing. For me and some neighbors down in my area, we are having issues with our slab foundations sinking or moving or whatever conditions they have. And then at the same time, I'm looking to see if we can't do something more for affordable housing. And this will be just an additional expense to the affordable housing. So I'm hoping that if there is some kind of compromise that can be worked out on it. Mr. Loggy, you made a comment up here. I'd like to have you address a question for me, if please.
Should have sat closer, Jeff. Getting exercise today. Chair recognizes Jeff Loggy.
Mr.
Announce myself again?
No, we got you now.
Okay, sounds good.
Once is enough for me, anyway. Mr. Loggy, would you address the point about where you were saying that in areas that could be developed, is the way I was hearing it, is that there would be essentially a minimal amount of soil testing done in this area?
Okay, soil testing is, I am not a soils engineer. I mean, I am an engineer, but not a soils professional. But essentially what this ordinance does is essentially it's going to require when you get a building permit, every contractor will have to consult with a soils engineer professional. And like we said earlier, that could be very minimal. If you're on the west side of town, and you're in the hard red clay and things like that, really it's going to be minimal, and it's going to be about an hour's worth of time for that soils. Where the cost comes in is essentially if you have to do any work above that. You know, and like Dane had said earlier, you know, I mean, the overdig is more work. You have to dig it out, and then you have to put it back in, compact it, water it as you need, and get it to the right compaction. So, you know, the consultation, the way we have it in here, is in lieu of doing full-fledged soils tests on every property. And that's essentially the light part of this. What's going to happen is if you're consulting on every job, you're going to catch those foundations that really should be getting over excavated. And that is where the cost comes in. And that's the hardship. That's where the big bucks start. And yeah, as affordability goes, I don't know what the alternatives are. I truly don't, because basement floors are the most impacted. The foundations, and what I've learned, and I've built on several different soils in here, is the foundations are typically fine. There's enough down pressure where the foundations are going to stay relatively solid, and they're not going to move. What happens is the floor moves inside of the structure, and it can push your subfloor up on your main floor. You know, you can get around it if you do crawl spaces somewhat. You know, you can over excavate the perimeter or whatever it may be. You don't have a floor heaving issue inside. So, you know, that's kind of where the boundary is. This is kind of a two-phase. And so instead of doing full-fledged soils tests on every lot, there's essentially a consultation, and then between you and the engineer, you'll determine how much more needs to get done or nothing. And then you have stage two. Yes, you are in susceptible, expansive soils. Now it's time to determine how much overdig we have to do.
Understand. And then the other issue that I'm dealing with right now is the affordable housing, because there will be occasions when we have that opportunity to move it into a lot, and probably going to be a small lot. And so what this is going to be doing for us is requiring additional testing, soil testing for this lot that we're trying to get affordable housing on.
I mean, at a minimum, you know, of every lot, you're going to have, if you have a consultation, you're probably going to have $200 to $400 tied up on that site observation. So you're going to have that added on to every cost, or to every project. It's from there on where the cost goes up. If it is determined you have expansive soils, yes, affordability is a huge issue, and it's a huge issue nationwide when you have houses that have doubled in price in say the last 10 years to 12 years, and that's hard to swallow. So now every time something happens, you know, even with a code change, you really got to look at it and say, you know, what is the best value? But the thing with soils, to go back in and tear a floor out in a house that is finished and maybe not accessible with equipment. You know, we're talking hand tools and things like that if it would be a garden level versus a walkout. That's why the remediation cost is so high, is you're dealing in a finished structure, and if that basement's finished, that just adds more cost on. So, you know, it's kind of that fine line. It's a give and take just under every issue. When you have it, you know, which way do you go? And I hate to see we're going to add on $4,000 to $10,000 onto every house. It's hard to swallow, but as a builder and developer, I've seen both sides of it, and you know, not so bad idea to have a consultation with a soils professional.
Understand, and that's the quandary that I'm dealing with, because personally I went through at least reconstruction, putting piers into my home that I purchased. It was about 20% of the cost of the value of the house to add on to it. So that's my quandary is, and back in that time frame, they did not do any inspections at all. And so if we can come up with something, and I need to do some more research on this, I grant you, to figure out what we're going to do with this, because I have this issue down in the old Robbinsdale area of town. Many basements are failing, and at the same time, I'm trying to figure out what we can do for affordable housing, how we can justify this cost for affordable housing. And we definitely need more affordable housing. So if you can come up with some more data, some more information for me between now and Monday, I'd appreciate it. Thank you. And Mr. Billings, just a short question, you can remain there, station there, is that on the structures that you're showing a sample of here, is it fair to say that when we add these structures into a home, that the cost will be going up as in addition to traditional construction?
Thank you. Typically, with the modern construction we use here is what we see every day. The old legacy type construction is, and these guys are more of an expert at it than I am in the cost component of it, but the legacy construction, or the old typical full dimensional material, is more expensive, both from a material standpoint and a labor standpoint. The manufactured materials, engineered products are straight. They span long distances. They are designed to carry loads well, just as the legacy stuff. The problem with this is the strength of this component relies upon every piece of it intact. A lot of little pieces all tied together. Where the legacy materials are the typical 2x10, 2x12, 2x8 type of material, it gains its strength through mass, through sheer size. And so on the typical floor truss, floor joist assembly, 2x10, 2x8, 2x12, it takes a lot of heat, energy, and time to deteriorate that to a point where it'll fail. Whether it's a floor truss assembly that uses truss clips or truss plates, they're each, this type of truss here, the silver plates that you can see on it are the physical attachment points. There isn't any glue or other mechanical fasteners. And so the fire reacts with those components, causing the material to pyrolyze or burn away behind it and fall out. And so then those pieces fall away, and you lose the structural support of that. That truss by itself is very, very strong and performs in every situation except fire. So the TGI component, TJIs, with the OSB type of material, it's a multi-strand material in between, fails fairly quickly. The center web burns out, it falls apart, and it can't support itself. So, and we see a lot of, a considerable amount of that. So, I don't know if I answered your question, Mr. Chief.
Thank you, Chief. I think I'll have some more questions for you between now and Monday night. Thank you.
Thank you.
Primarily in the area of when we get into affordable housing again, is my, where I'm really interested in what we can do for affordable housing and still at the same time protect the individuals wherever, not just affordable housing, but wherever. Because I understand totally what you're talking about, the firefighters going into a structure and falling through the floor. I get that. Appreciate your comments.
Thank you. If I might add very briefly.
Yes, please.
There are 7 other alternative processes that I've discovered that, or that found, that are either a treated material that prevents it from burning so rapidly, or there's other protective measures other than the half-inch sheetrock itself. And so there's other options out there. Fire sprinkler protection is one of them, the treated material, the sheetrock membrane. There's a lot of different ways to do it. So.
And there's also a spray-on material, if I understand it correctly.
Correct.
Yes.
Correct.
Thank you.
All of them add cost, but it's...
Yes.
But there are options. Thank you.
Thank you, Mr. Chair.
Chair recognizes Alderman Jerry Wright.
Maybe for Dave or Brad, what about the engineered, I wouldn't call it engineered field, where you have excavated, let's say on a hillside, or you bring fill in? Where does that fit in for testing for soils? Do we do that now, or is that not done? Because that is a big factor in.
And Brad from Development Services.
Yes.
If we know that it's on fill, we require some kind of engineer report or engineer drawing, something like that. Sometimes we don't know. Sometimes you don't know until the excavation is done, because you can see the strata, of the soils. So it depends. But so not typically we're not getting those. No. There is no coordinated effort right now between the development part, where they do a development plan for the subdivision, and where the houses are going to be sitting.
Let me ask Brett then, or maybe Dave, when we do a subdivision and we're doing moving of soils, and we're taking borrow and putting into a fill, do we test the fill? Is that required? for load-bearing capacity for structures? Or
You know,
not?
we don't as planners, and I don't believe
I mean, engineers. I know you
engineering
don't as
does
planners,
either, but that might be a good question for Dale or Terry when they're here on Monday.
Dave, do you know?
Well, no, but you know, one of the things that came up in our discovery process of this issue is, you know, the proper place for soils testing is in the development stage. Unfortunately, the only requirements that come into play in the development stage is they do borings in the streets. As typical. And if when the developer is developing the lots, if it would be far less expensive, and they can pass that cost on to the lot cost at a much reduced rate than if it ends up in the responsibility of the builder to the consumer, or if a consumer just goes and buys a lot, not knowing what they're faced with, if they have to overdig and spend $10,000, they don't have that even on their radar screen. So that was one thing that we did have a discussion about at the board level, was, you know, ultimately, that's probably where this should be placed, on the responsibility of the developer. But in the meantime, I think we've come up with the best plan, and that is what we've been proposing, is that the builder, before they can place foundation and footers, they have to have that letter from a geotech.
I have a tendency to agree with your discussion on should be at the development stage of the subdivision, where the cost can be spread out as needed, and also get an overall estimate of the situation, and not spend money we don't have to, but do get things done that need to be done. And one of the areas I think we have historically had problems with is soil that's moved from a borrow to a fill. And like you said, the only testing is in the street and not in the lots. Is that true in the subdivision area?
Depends on, there's a phase one. You can,
So I guess I said earlier, this is going to take a lot more discussion than probably Monday night, than you're getting the tip of it right now. So, okay, but thank you. Go ahead. Start.
Well, I was just going to respond to your testing outside of the street. You know, it truly depends on the developer. If he has a draw that's going to be filled and he knows there's a building site on it, a lot of times he'll make sure that's part of the contract, either with the excavator or himself with the soils professional, and say, can you make sure make sure we're at compaction on those deep fill areas. So, you know, but it's nothing mandatory, but it does get done, you know, within some of the developments if they know they're going to be building on certain areas.
I like the word some.
Yeah, I mean, it's not mandatory by any means, so.
Okay.
any further?
More to follow, but not tonight.
Okay, remember, the motion a little late in the game now is to move the council without recommendation. Ron Weifenbach.
Thank you, Mr. Chairman. I just have a couple of comments. I can't sit up here and listen to affordable housing conversations when we ourselves sit up here and raise the fees, the taxes, and add on just crazy red tape for these guys. And when I do mortgages all day long, I can tell you guys that 25 to 30% of the house payment is taxes. Drainage fee taxes, whatever the taxes may be that you guys sit up here and add on, that we do, I should say, and don't even take it into consideration. That being said, Mr. Asbridge, I appreciate what you're saying there, and I think that's a good step forward, is looking at the development side of it, because that's the only way you're going to level the playing field with everybody, is if it's done all at one level there, and that we're looking at it. Because I'll guarantee you right now, is anybody can drive around our town and see the roads, we don't do a good job at it. We may test it, but what would we do with the test afterwards? I have no idea, because it's obvious that there's areas there that were tested, but nothing was ever done with the results of the test. So, and I understand what you're saying about, you know, if we get people on the same level playing field, then one guy's not over here building just willy-nilly and and his house is going to fall apart, and then consumer beware. That's where the problem comes in, is the consumer beware. We've got probably so much red tape wrapped up in this IBC code that if there's trade-offs that you guys know of, I mean, I go up in Red Rock and I look at those really nice houses up there, and I look at that goofy boulevard, and I live in the Elks Estates where they have rollover curb, and they have the curb that goes to the sidewalk, and it gives the opportunity for me to park 2 vehicles in there, not 1.5. And it also gives me the opportunity so that the builder doesn't have to come back and knock that sidewalk out and knock the curb back out and put it back in and all that goofy stuff. If there's some trade-offs, if we decide that for some reason that the fire department may have some legitimate issues there, if there's a trade-off that we can make with you guys, you got to bring it forward for us. If it makes sense, like in some of these subdivisions, to move these sidewalks forward, I've never had a good answer why we don't. I have not. It's just, well, we're doing it. And that seems to be what's happening to you guys today. We keep piling on, and pretty soon, for one thing, you have to buy the copyrighted book to understand what you're even doing. You know, there's a lot of politics that go into it. Some guy finds out that there's one little thing that he can go sell George Soros' group at the UN, and you guys all got to, you know, put it on, even if it makes sense or not. So if there's some cost trade-offs, because I know cost is a factor, bring them forward, guys, because like I think Alderman Wright had said, I don't think this conversation should be ended yet. I think we need to look at the costs, we need to look at the safeties and find a balance that makes sense. And if you guys think that moving the sidewalks out, that'll save you money, not knocking out the driveways, and we can maybe do some offsets or something, bring it forward, because you guys know better than we do. Or maybe Chad knows a little bit more than I do about it, but my experience is there's got to be some offsets in there that we can help that makes sense. Some things that, you know, they're outdated, that make any sense anymore. Maybe we need to replace it with something else, and we can offset and keep that price, you know, reasonable as possible, even though overall in the long picture we're affecting it more than you guys are by adding on. We're adding on fees, taxes, electric bills, those types of things. I mean, it's astounding to think that I have some properties with no debt service at all, but by the time you pay the water, the electric, the gas, the taxes, the insurance, you're at $500 a month per unit. Is that affordable? Just somebody that has a minimum wage job? I don't know. So that's a whole other argument. Appreciate it. I'm done. Thanks.
Darla Drew, Jerry Wright, excuse me. It shows up as Darla Drew because he's supposed to sit in today. That's why. It was not intentional.
Thanks, Chair. Brett, would you make sure that you guys have an internal staff meeting with engineering and Public Works on this issue before Monday night, so we're prepared to discuss it more on what we do before? Thank you.
Great, I will.
Okay, any further discussion? I'll just have one thing for Mr. Weifenbach. The rollover curbs were taken out about 2003, I think, 2002, something like that. And there was quite a bit of pushback from the development community, but evidently didn't get through because it was once again, a public safety issue. And quite frankly, I don't agree with it. But anyway, that's. And we no longer require developers to install sidewalks ahead of time. That's part of one of the revisions we have done too. That's now a burden of the builder, so you don't have to rip out the sidewalk anymore. But anyway, okay, the motion is to send to council without recommendation. Any further discussion? All in favor say aye. Aye. Opposed? Motion carries. Item number 20 is introduction and first reading of ordinance 6440 to fix an error in section 15.14.150 of Rapid City Municipal Code concerning International Property Maintenance Code.
So moved.
Motion approved by Nordstrom, second by Wright. Any further discussion? All in favor say aye. Aye. Motion carries. Item number 21 is introduction and first reading of ordinance 6041, repealing international existing building code by deleting chapter 15.15 of the Rapid City Municipal Code.
So moved.
Motion by Nordstrom, second by Wright, and the chair recognizes Richie Nordstrom.
I just want to make sure that everybody understands we're deleting a whole chapter here on this. And it probably has, anyway, we're just deleting some more red tape. Thank you.
Okay. Any further discussion? All in favor say aye. Opposed? You want to? Motion carries. Item number 22 is introduction and first reading of ordinance 6042, amending the climatic tables international building code by amending section 15.12.580 of the Rapid City Municipal Code.
So moved.
Motion by Nordstrom, second by Weifenbach. Any further discussion? All in favor say aye. Aye. Motion carries. Just trying to change it up a little bit. Item number 23, second reading and recommendation of ordinance 6036 to amend provisions concerning appointments to the Rapid City Planning Commission by amending sections 2.0 260.020, and 260.030, and 260.11.00 of the Rapid Municipal Code.
Second.
Motion by Weifenbach, second by Nordstrom. I need to get reading glasses. All in favor, say aye.
Please.
Opposed? Motion carries. Can I borrow yours, Grandpa? Item number 24, second reading and recommendation of ordinance 6031 to authorize the Planning Commission to act as a zoning board of adjustment and by amending section 17.54.010 of the Rapid City Municipal Code.
So moved.
Motion by Nordstrom, second by Wright. All in favor, say aye.
Aye.
Motion carries. Item number 25, second reading and recommendation of ordinance 6037 to change the name of Rapid Street between 3rd and 5th Street to Nico Street and between 6th Street and Mount Rushmore Road to Apollo Street by amending section 10.48.010 and 10.08050 and 17.3605.010 of the Rapid City Municipal Code. All in favor?
Second.
Motion by Weifenbach, second by Nordstrom. All in favor, say aye.
Aye.
Opposed, motion carries. Man. Okay, item number 26 is Alderman Weifenbach, repeal ordinance 6018, consolidating the city's vision fund and capital improvement funds into separate accounts within a united fund by amending chapter 3.16 of the Rapid Municipal Code. Chair recognizes Alderman Ron Weifenbach.
Thank you, Mr. Chair, and I'm trying to figure out a motion that I guess would direct staff or direct to unwind the connection between the CIP fund and the vision fund to put them back to where they were. That'd be my motion, if that makes sense to the legal chair.
Motion is to direct staff to return this to the previous version. Do I have a second? Motion dies from lack of a second. You still have the floor, sir.
I just wanted to say that I think that when we had the election, I think Mr. Mason had alluded to that fact that the reason that these were put together was to allow debt service coverage for $180 million purchase of a new civic center or whatever it is. And now with them being all combined into the vision funds, it still doesn't eliminate our risk with the CIP to have any other things done to it. And I think that just granting the wishes of the people in our community to say, you know what, infrastructure is important to us, and I'd like to, but I obviously can't even get a second on this. The fact is to increase the CIP funds and really get things done. Everybody that sits up here talks about fixing potholes, talks about fixing streets, talks about fixing water, sewer, infrastructure stuff, but nothing gets done. And they said, well, property tax revenue. Oh, we got to have affordable houses. Well, we can't increase property tax. That's not going to happen. Sales tax revenue, a portion of it is paid by visitors of Rapid City. But I'm telling you, those same visitors use the same streets that we do. They use the same water and sewer infrastructure. They use the same fire and safety. They use everything that we do. They wear out our streets just like we do. This is an opportunity to get it right. You don't want to raise taxes so you have affordable housing? Increase the CIP funds and fix the roads. Let's get on with it. It's pretty simple. All you got to do, but having these twisted together from that very onset was one of the reasons that they're not building a civic center today. People were afraid of losing what little that they were getting from this for the infrastructure part of it. And now today, this group is unwilling to unwind it, just so we go on the record understanding that. We talk about affordable housing again. It just irks me to think that we have an opportunity to fix these streets. You drive down them every day, and there's opportunity to fix them. And all we have to do is add a little money to it. We could repeal the rain tax simply by taking the money from the vision funds, fixing these things, doing it right, having it done complete, and then we could finally get back on the curve. If we continue like we are right now, basically what we're doing is we're digressing the back part of that curve every year that we go by, that we don't interject enough funding into that to get on the front end of that curve. If we could get on the front end of that curve, then we could have the conversation about maintaining what we've done and what we've fixed. This council, they want to talk about visionaries and all that stuff. I can guarantee you, if you guys read what your mission statement is as a council person, it says to get the most bang for your buck and to provide safety, and streets, water, sewer for the citizens of Rapid City. That's your main purpose. It doesn't say anything about building giant civic centers or any of that stuff. It talks about being able to have your ability to block and tackle. Like if you're a Super Bowl team, the teams that go to the Super Bowl, the team that go to the NBA Finals are teams that understand how to do the basics. They got the basics down and they're good at it. They don't go from just putting a team together to playing in the NBA Finals or the Super Bowl. They learn how to block, tackle, and do those types of things. We have an opportunity to do that today. I understand if my colleagues don't want to do it, I'll bring it back again and again and again. Unwind this thing. Give the confidence back to the people that we're not going to try to jam something down their throat. That's what they think. If they're not telling you that, then I guess I'm wrong. It'll give us an opportunity to increase our funding into our CIP at the same time, get back on the curb so we can, instead of having the conversation about failed infrastructure, we can look at, hey, look, we've got this taken care of. Now we're looking at maintaining it. How do we maintain it going forward? Sales tax is an important piece of the pie for the revenue to fix the infrastructure in the city. Anybody who says it's not doesn't understand that people don't just come out of the sky, land in a retail store, and buy something. They drive on the streets. They have the water, sewer, safety. They have all the same things as people that live here. That's why we charge it. Thank you.
Chair recognizes Richie Nordstrom.
Thank you, Mr. Chair. I'd like to make a motion to acknowledge the discussion.
Motion is to acknowledge. Do we have a second? Motion dies from lack of a second. What are you doing?
I would send this to council without recommendation.
So, second by Weifenbach. Okay, motion is to acknowledge. Motion by Nordstrom, second by Weifenbach. Mr. Nordstrom, you have the floor.
Thank you, Mr. Chair, and thank you for the second. If I can point to a few things that, and I'm not going to address them all, but what Mr. Weifenbach brought up several points that I think need just a little bit more discussion, primarily the fixing of the streets. Usually we spend about $20 million a year, round numbers, on fixing streets and potholes is what we're after. And if you had a chance to take a look at yesterday's Public Works Committee meeting, there was the starts of several projects on there. I didn't count them, but I suspect there's close to 20 different projects that are coming off the CIP list that are moving forward. And that's primarily where all of these projects are coming from, and nothing has changed from that off the CIP. And there's so many other points that need conversation. I'll yield to my colleagues here that Mr. Weifenbach brought up. I'll have to go back and re-listen to the tape here for all the comments. And when it came up to affordable housing, points of it is that I will keep looking for additional revenues and other sources that we can have for affordable housing and not have to rely on CIP for affordable housing, because I want to see that going into street maintenance and repairs and all the utilities that go along with that. And then there's other things that I'm not even mentioning that take place within CIP. There's a lot of good things that happen in CIP currently and have not changed and will continue moving forward. With that, Mr. Chair, thank you. I'll yield the floor.
Thank you, Mr. Nordstrom. Second. Chair will recognize Jerry Wright.
Also known as Darla Drew.
Yes, also known as Darla Drew.
Well, Ron's absolutely right. The teams that succeed know the basics, but they also know the rules. And the ordinance 6018, clearly states there shall be two separate accounts within the fund. There's capital improvements account to finance and the vision fund. And our finance officer can address why that's done and how it works. And in CIP, the city council shall approve a 5-year plan for financing projects and purchases out of this account. And the purpose shall be for streets and drainage and so forth, without reading everything to everybody, which is probably demanded. There's also the vision account. The city council shall by resolution adopt a plan for projects or programs to be funded in whole or in part from the vision account. So they both exist. They still exist. They exist in the ordinance. The question is, maybe is because of the Civic Center project, the ordinance had that covered. Do we want to change some of that? I don't know. But I think that there was a great deal of discussion on how we're going to go about the expenditure of this money, and it had a lot of discussion that had to do things with the process, how it was done, how committees were appointed, and the process of how projects were evaluated. There was more to this than just the Civic Center project. And I think this evolved over about a 4 or 5 year period. It didn't happen just in the last 6 months. I think that the ordinance as written was to streamline and help the process become more efficient, and it clearly states that the staff will come up with a list of projects, as will a committee appointed by the mayor of, I think, 8 citizens that will develop a project list, and the council will decide what are the priorities. It's very little different from what it was in the past, except there's 1 committee instead of 3 citizens. I don't think this is a bad ordinance. We can clean it up and talk about how we want to address the Civic Center, but I would love to have this money that we're going to spend on the Civic Center available for streets and so forth. I would love to have that, because one of my platforms has always been, let's fix our streets. My estimate is we're spending about 8 or 9 million. We should be spending 14 or 15 million. Our engineering department said we should be spending twice as much, and that's because I'm taking the grace of our streets lasting 40 years instead of 20. But if we take that money and we spend it on streets and all that kind of stuff, we are not going to have a source of revenue, in my opinion, or that I'm aware of, to pay for the repairs and fixing of the Civic Center or the upgrade of the Civic Center when that decision is made. It's not there. That was how it was paid for originally, with sales tax. And if we commit that money to other programs, high risk it won't be available. And how do we fund it then if we need to? I think that's a serious question that needs to be talked about. I don't think the ordinance needs to be thrown out, maybe tuned, but not thrown out. Thank you.
Anybody have any problem with me recognizing the mayor?
I recognize him.
Chair recognizes Sam Quaker.
Well, good afternoon, Mr. Chair. If I can have your permission, I'd like to ask Alderman Weifenbach a question. And my question is this: Ron, are you calling for a full repeal of 6018, or are you calling for an unwind of the part about separate accounts within a unified fund? You'd like to go to separate accounts with separate funds.
That is correct, Mr. Mayor.
So you're not calling for a total repeal of 6018?
No.
So, first of all, I don't think the Rapid City Journal is here, and I wish they were, because I believe that the recent article pit Ron and I against each other in an unfair way, because what I had said was that there wasn't a need to do anything at this moment, especially when you got the after action review going on, and I can understand, based on the discussion during the recent debate, that this was a source of concern. I would say that if we move forward on a change that we not repeal the entire ordinance, you could simply unwind the part that causes concern. I am a little bit disappointed that the debate seems to be about that. The insinuation is that this ordinance, as it sits now, is somehow negatively impacting the amount of money spent on streets. And if you look at yesterday's Public Works agenda, that's a silly notion. We are spending an incredible amount of money on streets. Let's keep this to the philosophical argument that it is. And the philosophical argument is that if we would have spent $180 million, and in order to have debt service coverage and get a lower interest rate, that Ordinance 6018, what it did is to take the penny, which is all parts of that penny, and put them in separate accounts within a unified fund. And by no means would it trigger a fire sale of the other 2 parts of the fund. It would trigger if things went to a hot place in a handbasket, it would trigger a discussion at the council, and then you'd have to decide where it would come from. It allowed us to get a better interest rate. We have to understand that we weren't putting more money into streets or less money into streets with Ordinance 6018. So I think what Ron and I agree on is that right at this moment, that provision of 6018, it isn't doing any harm, but it is creating uncertainty and questions. And for that reason, you could certainly repeal that part of it while maintaining the rest of it. I've sat through several processes of 2012, and I've seen all the games playing that takes place on defining what's civic improvements and what's infrastructure and what's economic development. And those changes in 6018 were good changes, and there's been no controversy on that part of the ordinance that I'm aware of. So, Ron, maybe you want to get a clear motion on the floor that makes it clear what you'd like to do. But I'm glad we're on the same page on that part of it. Thank you.
You already spoken? Yeah, you already spoke.
If
So,
I
no,
I let him speak.
No, you already spoke, so.
Okay, I'll wait.
Ron, I was making sure. Chair recognizes Ron out. Reifenbach.
Thank you, Mr. Chair, and thank you, Mr. Mayor. I think you clarified what I tried to say, but I thought I was pretty clear about the fact that I wanted to direct staff to separate the funds from being unified. And I disagree with just one thing you said, in that the fact that we had to have this debt service coverage. It wasn't a matter of whether it lowered the rate or not, because it was at risk, and it is at risk as long as they're unified anytime. I think the people, like you said, had mentioned, the people in the community feel somewhat at risk. If we completely go back to where it was, then there's a guarantee that that's not at risk anymore. That's not a question. And one of the questions, one question rises to another. Okay, if they're unified, then does that give the council the ability to come back with a $180 million project? Yes, it does. So that being said, that's the reason I want to untie them so that people are clearly understand CIP is not going to be affected. There's not a chance for it to be affected because it won't be in the unified fund anymore. But I understand that it's up to the council, just like I understand anything that, when we had the Civic Center conversation, it was the fact of the matter is you can have as many committees and all those things as you want. It has to go through us as a vote at some point. So, with my colleagues, if they have no interest in it, fine, as long as they're on the record. If they have no interest in it, I'm okay with that. But I want people to know I listen to my people in my ward. I get phone calls from them. This is what they're telling me to do. I don't sit at home and imagine these things to come up here and cause controversy. I just appreciated the fact that they would listen and ask a question. Thank you. And I appreciate again, Mr. Mayor, you clarifying that.
Chair recognizes Jerry Wright.
I guess I have no problem establishing the two funds. I thought that was an issue for bonding, of course, and anything like that, but I'd certainly support that. That's not an issue. But I don't want to repeal all of 6018 for the same reason the mayor stated. So we have a motion to send this to council.
Council without recommendation. Or take a motion to acknowledge right now.
Call the question.
I'm sure we'll be talking about it Monday night. Just a wild guess, but I'm thinking it'll come back up. Yeah, I'm sure we'll be having that conversation Monday night. So
we will.
And then, may I, one more time?
Alderman
please.
Quaker?
Can I make a suggestion? That you get a motion on the floor to draft the change that you're looking for, so that I don't think it'll take a lot of work to draft it. Get a motion on the floor to draft the change that you're looking at and bring it to the council for discussion. And if you can't get it done in 5 days, and make the motion here in committee and bring it back here in 2 weeks and discuss it in committee. But I don't see any harm in having the debate on. Right now, you're debating something that's somewhat theoretical. If you can have an ordinance draft in front of you that allows you to articulate the issue better, and I can help with that. I mean, I can ask for it to be drafted, but there's a lot of other things going on right now too that staff is working on. I don't know if we can get it done by Monday night, but I'd like to suggest that you get a motion on the floor to ask that the ordinance be drafted, not for a full repeal, but for an unwind of the separate accounts within the unified fund. Leave the rest alone, bring it back for a conversation, and by then we can hopefully get some input from Woody, our bond counsel, and from Joel, who's not here today, who both I think would have input on this.
For clarification purposes, the Because I understand that they're not currently wound together anyway, they're just guaranteeing each other essentially, is that correct, Pauline Sumption?
Thank you, Mr. Chair. We are accounting for them exactly how we have in the past. We have, I could tell you every single penny that's in the CIP versus the Vision Fund. The only thing that would be different would be for those people who, unless you're somebody who bought our bonds or a bank or our granting agencies never look at, is our audit. And then on the audit, instead of 2 columns, it would be 1 column. But for everything that we're doing downstairs, it is still completely separate. Does that clarify your question?
It does, but I'm trying to figure out why we would undo that process if it's they're still being spent as designated. Well, anyway, so the chair recognizes Jerry Wright.
Now make a motion that we draft a change to establish 2 separate and distinct accounts and funds for CIP and Vision. Leave the rest of it alone.
Do we not already have 2 distinct accounts is my question.
If the draft passes as requested, then the audit would continue to have 2 separate columns. But if it doesn't pass, then it would just be 1 column on the audit for both of the accounts, one being CIP, one being Vision Fund.
What's the overall effect in that case then? I mean, what's the difference between 2 accounts and 1 account? Just bonding lower interest rates, basically?
Basically, the way that it is currently, it gives us better coverage ratios, which would give us a lower interest rate if we're going to go out to bond. I will tell you, though, that just like the mayor said, where the way it is now, if we didn't have enough in the Vision account to pay for the bond, we wouldn't have to necessarily take it from the CIP account, even though that's joined. We could still come back as a council and find somewhere else to pay the difference. The same is in reverse. Just because they're separate funds doesn't mean the council at the time couldn't come in and say, we're going to take the shortfall from the CIP. So I understand what Alderman Weifenbach is trying to do, but it doesn't necessarily negate that from happening, I guess is my...
Okay, everybody understand the motion? Did I have a second? I'm sure I did, yeah, Weifenbach. Okay, motion by Wright, second by Weifenbach, and Mr. Wright, you have the floor.
I'm fine.
Okay. On Weifenbach?
Thank you, Mr. Chair. And I think if you listen to what Pauline said, you'll understand the exact argument that I'm making. It doesn't consist about this council, the next councils. They have to make steps to change that and be cognizant of what they're doing. Otherwise, the council can come along and just spend it all. And that's why, I'm not an advocate for saying that's the way things were done or whatever, but I am an advocate for saying that the people spoke. I mean, I think that if you listen, one of the issues is spending all that money and losing the confidence in the fact that that's available. And I appreciate Alderman Wright's consideration of bringing this back to the Legal and Finance. We can have another conversation. It'll give the mayor some time to weigh in on a little bit. I think he has tonight. And I think it'll give our legal counsel a little time to weigh in. But accounting-wise, doesn't matter. Money's money. In and out, money's money. But what matters is the legal responsibility and the accountability. Actually, if, like she had mentioned, if another council comes along and decides to spend it all, they can do that, and they can. I still think there's issues when you look at it that money's going to be tied to any and all as a guarantee for any and all funds. I mean, you can't go over and promise people. You can't promise the same amount of money to several different people. That's nonsense. You can't do that. I mean, you can't go out and do a CIP project and promise that money to that project, and then come along and promise that same money to another project. I think they call that, there's a word for that, it starts with an F, but the fact of the matter is if we separate these things, it'll bring back some confidence to the people that we're not going to come back with another $180 million project, what they basically spanked us for. And I appreciate it again, the mayor's clarification of it. Sometimes I don't communicate what I want, I know what it is in my head, and I appreciate Alderman Wright's, moving it to the Legal and Finance, having them draft it. We'd come back, we'll look at it, see if it makes sense. And in that time, you guys can do a little research and see if I'm right or wrong. Once that money's committed to something or another, it's committed. You can't commit it to 2 or 3 projects. That makes no sense. Thank you.
Alderman Richie Nordstrom.
Thank you, Mr. Chair. Just a clarification on the motion that was coming back. Now, if we're doing a draft on this motion of this unwinding here, separation of it. And just a clarification on this, and there was some discussion about the different steps that can take place on this. If one fund is short, we could borrow from another. But my question is, if either one of those is short, doesn't that mean the full penny for the general fund is short then as well at the same time? It is. So I'm not sure what the draft is going to be putting forward on this is going to do for clarification or understanding. So Mayor, if you can kind of help me out here, understanding what this draft would kind of look like.
I'm not sure, which is why we're asking for a draft. And we have, Joel isn't here today, Woody Woodson, our bond counsel, hasn't weighed in, and it just seems to me that this, in reading the original ordinance, it would be a partial rollback, and it shouldn't be that hard to bring forward a draft forward to Legal and Finance. And I think one of the pet peeves that I've heard in talking to council members is when half-baked issues come to the city council. You've had a very good discussion here in the committee. You're not quite ready to, in my observation, to take this to the full council. So go ahead and have a draft brought forward, and then in a couple of weeks you'll have Joel here, and you'll have a memo probably from Woody. And then you can have a full and robust discussion on it. So I think this is a good motion.
Clarify your question, sir?
Mayor, can you address my question about the consideration for the different steps in the process? If one is short, if one fund is short, then the whole sales tax is short, correct?
Look, Richie, here's the problem that I have when I'm talking to people in the community. People are under the impression that if one fund is short, that you're going to have a fire sale of the other fund. Now that isn't accurate. It's possible, but it's not automatic. If you get a draft, so you know what you're looking at, and you know the ramifications of, because there's positives to rolling this back, because there's also negatives to rolling this back, because it can impact your ability to bond in CIP, which right now is pay as you go. So does it matter at the moment? Probably not. But you need to go into this eyes wide open. So why don't you guys just stop belaboring the point today? It's a point that needs to be belabored, but get more information in front of you. We're willing to help with that, and bring it back in a couple of weeks and have the conversation.
Call the question.
Yield.
He still has the floor. Question's been called. Any further? Anybody objections up? Wade Neidberg would like to jump in if that's okay with everybody for a second.
I just wanted to ask for a clarification. Did you want the draft at next Legal and Finance in 2 weeks or on Monday night?
Is that enough time? Can we do it till after the election? Okay, any further discussion? Any further discussion? All in favor say aye. Aye. Opposed? Motion carries. Parking, how appropriate, because we're all going to need more time. Item number 27 is discussion proposed rates and hours for parking ordinance. Chair recognizes Richie Nordstrom.
Thank you, Mr. Chairman. I'll start off with a motion to increase the non-metered parking for downtown to from 2 hours to 3 hours. And I'll look to either Pauline or probably Wade for if we need boundaries or if we need any more additions to this motion.
Okay.
But essentially 2 hours to 3 hours for non-metered parking in the downtown area.
Jerry?
I'll second it.
Okay. We have a second? Is it, a quick clarification, isn't this already part of the new first reading? That's what I thought.
The ordinance attached on the next item, that's what that does. It
So
changes.
it would be appropriate to table this item and move on to the next item and have further discussion about parking at the next?
If that's what you're inclined to do, I would say, yeah, you could acknowledge this discussion, move to the next. The next item is an ordinance that does exactly that.
We're going to have the same discussion at the next item is my point, so. Would anybody,
I'm
would you
okay
care
with
to, you care to change your motion to acknowledge this?
Sure. No.
Second by wife, right? Okay, seconder, okay. So motion is to acknowledge. Any further discussion? All in favor, say aye. Aye. Opposed, motion carries. Item number 28 is introduction and first reading of ordinance 6045 to increase the amount of time allowed on-street parking in downtown and repeal the graduated penalty for timed parking violations by amending section 10.44.010, 10.44.070, and 10.40205 of the Rapid City Municipal Code. Chair recognizes Ron Weifenbach.
Thank you, Mr. Chair. I'll make a motion to approve.
Motion approved by Weifenbach.
Second.
Second by Nordstrom. Mr. Weifenbach, you have the floor.
Thank you. I made the mistake last time when a parking thing came through of just voting it through. I've talked to some of the downtown people about this. They're okay with it, but they understand the ramifications of it or whatever, and it's going to meet a lot of their needs. But I really would like, and I'm hoping Monday night, I think Pauline will probably have to weigh in there. I don't care if she weighs in today or in the legal weighs in today because of the parking bonds and stuff like that. So I don't know that we listened to her last time, and to that I apologize. So hopefully this will meet the needs of what she's trying to accomplish. So I can wait till Monday to hear that. Thank you.
Thank you. I think we listened to her. I'm just a parking savant. Okay, Mr. Chair recognizes Richie Nordstrom.
I just want to make sure everybody understands that we're moving this from 2 hours to 3 hours in the appropriate places, and then removing the courtesy ticket and everything else that we had in previous schedule. That's all planning to be removed, and then go strictly with Alderman Chad Lewis's original motion to go to the $10 fine. So I'm glad he brought this up in the past, and it's another person we don't listen to very often. There's a reason why, but thank you.
Oh, how much better the city would be. Chair recognizes Pauline Sumption.
Thank you, Mr. Chair. Just to address Alderman Weifenbach, my memo is attached to the both items 27 and 28, giving basically the three options that we have, which would be to leave it the way it is, go back to $5, or go to this $10 and 3 hour time limits. Contrary to popular belief and what was said at the last council meeting, I did analyze the graduated fines. And so when I look at it again, and I will say I analyzed it from the city's perspective, because I'm not privy to any of the business's proprietary information. So what is in this ordinance is the recommendation to go to $10 parking tickets straight across the board, as well as the 3 hour non-metered parking. In talking with Police Chief Carl Jagaris, the times that the parking enforcement could make their rounds would be approximately half of what they're currently doing. And so with increasing the hourly parking to 3 and increasing the fines, we're looking at about a wash there. Now on the metered parking, we don't really have a way to determine what's metered fees unless we get the database from parking enforcement and look at where the tickets are actually being done and where the meters are. And so this may have a little positive effect on the tickets at the metered spots. However, there are additional maintenance costs and upkeep, and if we're ever going to look to actually graduate to a more higher technology in our metering system, we would need the extra revenues to do so, to be able to meet our bond coverage requirements as well as do those additional things. There was something else I was going to say, and I can't remember what it was. Oh, I remember now. Something else that we talked about is the fact that until this ordinance is published and in place, the current graduated system will stay in place. So if anybody is on their courtesy or $10 or $15 or $25, those stay in place. They're still effective until after second reading and the resolution setting up the $10 fees. I know there are some people that are still only giving us $5, no matter what the dollar amount on their ticket is. If they don't pay the ticket in full, it stays on their account, and it could eventually add up to where they would get booted. So I would encourage those businesses that if they know of customers that have, or employees that have frequent parking tickets, to make sure that they are aware of this as well.
Thank you. Chair recognizes, which one of you spoke last? Darla Drew? I mean, Jerry, right.
Actually, Jerry talked last, so. I hope this will help the downtown, but I think that we need to have some kind of a discussion occur that reality, history has made what we have today, and I think that the city has historically been the manager and the enforcer of the parking issue downtown. But its success and failure is really in your hands. I'm speaking to those of you that are here, but the entire downtown community, business community. Because most of it's on right-of-way or it's in public structures, its success or its failure is really in your hands. We're here to kind of help do the job. So I think that strong communication and strong unity down in the downtown business district to make things work is going to help. The city doesn't want to be the bad guy. We need to know from you what will work. And if it fails, let's say if we can't pay our bonds for the parking structure, it's going to come back on probably the businesses downtown, that kind of stuff. So we need a good planning, good thinking, everything for it to succeed. And really the responsibility of it succeeding is in the hands of the businesses. Fair? And I think if there's parking issues down there, what are they? You know, do we have employees and owners parking in front of their businesses so people can't park? Do we have support staff or staff working there that don't have adequate safe parking? We can certainly work as a city to help solve that problem, but the responsibility is really going to rely upon the business community. And I look forward to working with you on this, of course, but we're not the miracle guys. Do you think we are? Thank you.
Chair recognizes Richie Nordstrom.
Thank you, Mr. Chair, and just want to underline and italicize that this ordinance will not go into effect for roughly 30 days, depending upon publication and all of that. So I'm glad Pauline mentioned that. So it's going to take about another month before we get all through the process. And then I'm glad Mr. Wright brought up some points about looking to the future and things to take into consideration, because I'm an advocate for a study for a downtown plan, which was brought up in through the major comprehensive plan for the city, and I anticipate that to be coming forward here pretty soon. And there's some other folks that I want to thank for bringing this up as well, bringing it to our attention. And that, first of all, is Mr. Kurt Small for sending out that Facebook comment, and we got a lot of comments from the public about this whole thing, so there's a large awareness that brought to us. And then also to the Destination Rapid City folks that brought it to our attention as well. And Suzette, thank you for bringing that all out. It brought a level of awareness that we weren't prepared for, and so thank you for that. And it's kind of fun to get educated in a little better way in this process, so thank you. With that, I'll yield.
And top third volley to Mr. Weifenbach.
Thanks. I hope 3 hours gives you plenty of time to finish those colors and perms. I would recommend, for the Downtown Association, maybe Destination Rapid City, if they foresee future needs changing. I think Pauline had mentioned about coming into the 20th century on parking downtown, that you guys start that conversation at some point if you're willing to go down in those trenches and go down that avenue, because it's going to be complicated. Because the thing that the downtown businesses have to understand is that the city is kind of more of an intermediary down there. We don't own, the city owns the streets and the parking, and that's why there's the fees and the meters and everything to pay for the maintenance on them. If you owned your own building at say, Rushmore Crossings or whatever, you would have common area maintenance fees, you would have all these other fees that went along with it. And you don't have that. You would also pay tax on the asphalt. Tax on asphalt is very, very expensive if anybody wants to venture down that road. So basically, an understanding from what our colleagues are saying here is the business owners know best what needs to be done down there. Okay, I would say move forward, and if you want to go down that road to look at something that's viable for the 20th century that can meet each individual's needs. Say if you're a hairstylist, or if you're a movie theater guy, or if you're somebody who's just, people come in and out in an office. you know, and moving into the 20th century by having some updated parking meters and stuff like that, what the cost may be. I think the burden for that's going to lay on the downtown people. And I think that Alderman Wright had mentioned that we're willing to work with you guys on it. We're not the end-all, cure-all, though. That to be understood, because for whatever political pressures that play into it. So if you have time now to be able to move forward in the future to look at it, I think that would behoove you guys, so you don't have us coming up here and not vetting something and then causing a real problem for people. So thank you.
Okay, motion is to approve. Remember, when you put this on Facebook, that's Lewis, Lewis. Okay, any further discussion? All in favor, say aye.
Aye.
Motion carries. Motion adjourned. All in favor, say aye. Motion carries. We're now adjourned.